Good afternoon. Welcome to our webinar on the Department of Transportation's DBE program, or the Disadvantaged Business Program. For the next hour, my colleague Jackie Unger and I will be presenting on this program, which has been in existence for many years, but not as widely known by many small businesses, particularly those owned by individuals that participate in other small business programs, such as the 8A, Service Disabled Veteran-Owned Small Business, Women-Owned Small Business, and Hub Zone programs. Our goal today is to generally outline how this program works, particularly for those attendees who are not familiar with the program, or know it exists, but not necessarily know all of the particulars of the program. We hope to touch upon the basic requirements of the program, explain how the program works, and answer questions that our attendees may have during the presentation. Your presenters today are Jackie Unger and yours truly, Tony Franco, with the law firm of Pilero Mazza. But before we get started, just want to make sure everyone realizes that every of the information we're providing here is for informational purposes only. It's not legal advice. If there's any particular questions you later have that are unique to your situation, you should really contact counsel. We'd be happy to answer any questions you may have. But this is just a general overview of the program without providing legal advice the way we normally would if someone came to our office and sought specific information about the program particular to their company or their eligibility. As many of you may know, Pilero Mazza is a small firm here in Washington, D.C. With a nationwide practice. We make an effort to keep our client base and family, friends, and associates and research partners aware of different developments in the government contracting world and that may impact small businesses. And we try to do that through the webinars like this. We also have what's called a blog and the PMP Legal Minute and Legal Advisor. And if you want to receive our weekly update, please send us an email and we will put you on our mailing list so that you receive weekly emails from us regarding things that are happening in the government contracting world that would be of interest to companies that are small and also medium and large, as we do also represent many companies that are medium-sized and large and doing business with small businesses and want to make sure that they're following the rules properly. Turning to this presentation, the reason we decided to give it was right after the elections when President Trump was elected. We realized that one of the biggest parts of his platform was a significant investment in infrastructure. For many years now, there has been discussions about the need for the federal government to spend more on bridges and highways and just building the deteriorating infrastructure that we have. And with President Trump having promised to do this, and it also being a platform that the Democratic Party has been pushing, it looked like this may be something that will have some legs and potentially move forward in the next 4 years. Now, we have been hearing recently that there are some issues regarding whether an infrastructure bill will be able to pass through with all the other things that are pending on the Hill, such as healthcare reform and taxes. But, there are 4 years in front of us, and so at any point in time, the funding for infrastructure investment may come through, and that will probably all be funds that are funneled through the Department of Transportation's projects. And the way these funds normally work that basically then trickle down to DBEs is that what the Department of Transportation funds the state government, and the state governments then awards contracts to primes, who then bring onto their teams disadvantaged business enterprises to help the states and the federal government achieve their DBE goals. And with billions of dollars likely to hit the streets at some point in the next few years, we believe it's an important time for firms that are looking to expand their business base to view the DBE program as another opportunity. Now, as an overview of what we'll be discussing today, first we'll be discussing the purpose of the DBE program, then the DBE certification process, the certification standards for qualifying, requirements for remaining in the program, and then similar programs for minority business enterprises, which every attendee interested in the DBE program should be aware of, because there is a lot of confusion out there regarding these different programs. There's confusion regarding the 8A program and the SDB program, which are federal programs, but then there's also this DBE program, which is a federal program applied at the state level, but then the states also have their own programs. And so we will touch upon those towards the end of the presentation. Now, with regard to the purpose of the DBE program, as I mentioned earlier, the purpose of the DBE program is to make sure that federally funded projects essentially are trickled down to the states, so that the states then award contracts to companies that use DBEs for purposes of meeting the DBE goals. One of the things that the program is designed to do is to make sure that DBEs at the state level are treated fairly, and that all the monies that are going to the state in order to conduct all kinds of transportation projects get to DBEs. Almost all of these contracts that are awarded by the states with federally funded projects have these DBE goals. And the whole purpose of the program is to make sure that the states have established a process to determine whether a company is DBE, to then have companies certified by the states as DBEs, and then to make sure then that the prime contractors that are being awarded these contracts are using the DBEs properly, that they've indicated in their bids they're planning to use for purposes of meeting their DBE goals. For purposes of just a little bit of background, the program has been in existence since 1980, and it was established essentially as part of the authority of the Civil Rights Act of 1964. So it has always been viewed as a program designed to help individuals and groups that are deemed socially and economically disadvantaged. The program has been reauthorized by Congress several times, and most recently in the Fixing America's Surface Transportation Act. Through these statutes, Congress basically has mandated that the program should remain in place, and it is a program that is policed very carefully, because in the past it has been subject to constitutional challenge, and there actually have been Supreme Court cases in connection with this program where the Supreme Court has held that the way that these kinds of race-based programs are implemented are subject to strict scrutiny. So, over the years, the Department of Transportation and the states have really worked very, very, very hard to create some very detailed, complex regulations as to how it is that states can certify firms for the program and how firms eventually qualify for the program. Now, with regard to the contracting opportunities available, essentially the funds are provided to state and local transportation agencies that receive these funds. Usually it's directly to the state, but there may be other local transportation agencies that receive funds from the Department of Transportation, for example, airport authorities, etc. And the agencies are supposed to evaluate all their DOT-assisted contracts throughout the year to make sure that if they're going to be awarding contracts that in some way is funded by the Department of Transportation's federal dollars, that there are goals for the prime contractors to meet these DBE goals. And at the end of the year, the amount of those contracts or subcontract awards to DBEs should be consistent with what is in the contract regarding the participation goal. You should consider it similar to the federal subcontracting plan requirements, whereas many of you may know if you're a large business and you're bidding on contracts on a full and open competition, you need to have a plan to award contracts to small businesses and hub zone firms, 8As, etc. This is very similar to that, except you're dealing with DBEs as opposed to goals for hub zone firms and 8A firms. Keep in mind too that with regard to these regulations, when they were issued by the Department of Transportation, they issued them not only for purposes of companies that are seeking to be DBE certified, to understand how it is that they qualify and need to operate. There were also regulations that the Department of Transportation issued so that the recipients of DOT funds, that is the states and local transportation agencies, know how to put their programs together. Because even though this is a federal program run through regulations the Department of Transportation has issued, the different states then implement those regulations at the state level. And in doing so, they mirror the Department of Transportation's regulations because they all follow sort of a uniform program. But when the DOT issued these regulations, it also was very clear as to how the recipients of these funds are to be running their programs. So oftentimes people review these regulations. If you were to go to online and go into the Department of Transportation's webpage, you may see the regulations there. There's Q&As and information on the program that can be sometimes hard to follow because many of the provisions in the regs are more designed to tell states how it is that their programs should be run, or let prime contractors know what they should be doing when awarding subcontracts. So there's really three different constituencies that you could say are being addressed in the regulations, which can make them hard to follow. Now, with regard to the contracting opportunities available, there's a widespread understanding that most of the contracting opportunities under this program are for construction projects, because the Department of Transportation, when it is basically dispersing these funds, it tends to be for highway construction projects and transportation related, where there's going to be a lot of construction. But you should know that it's not limited to just construction projects. There are many significant requirements that are funded by the Department of Transportation that involve, for example, services, or they may involve engineering, landscaping, utilities, information technology. For example, for airport concessionaires and car rental concessions operations, those are run through the program. So keep in mind that to the extent some of you who are participating in the webinar are not construction companies, this doesn't mean that being a participant in the DBE program may not be helpful, because a prime contractor may have to provide certain services under one of these contracts that allows them to meet their DBE goals by awarding a subcontract to a company like yours.
I'm going to talk about the different players for a few minutes here. So, and Tony touched upon this a little bit, but with respect to the DOT distributes the funds each year to finance highway, transit, and aviation projects that are initiated by the state and local governments. At the national level, there 10% or more of the DOT's funds are supposed to go to DBEs, but the 10% is an aspirational goal. It's not a quota, and DOT doesn't penalize recipients. The recipients of the funds, who are the different state and local agencies, are referred to as recipients. So DOT won't penalize recipients for failing to meet their overall goals unless the recipient fails to administer their state or local DBE program in good faith, and we'll touch upon that a little bit later. The DBE program involves the 3 DOT operating administrations: the Federal Highway Administration, the Federal Aviation Administration, and the Federal Transit Administration. As Tony mentioned, a large portion of the DOT's funding goes towards construction projects. It's about 85%, and that's allocated to state highway and transportation agencies for highway construction. The balance is provided to local public transit and airport authorities for mass transit and airport facilities. The Federal Highway Administration also annually apportions up to $10 million to state transportation agencies for the purpose of carrying out a DBE supportive services program, which serves to provide training, assistance, and services to DBEs certified in the DBE program to increase their activity in the program and facilitate their development into self-sufficient organizations that are able to compete for these projects in the DBE program and outside of it. So states may seek that funding if they want to set up a supportive services program. So you can check into your state and see whether they provide those services. And then the FAA handles the funding that goes to the airport concessionaires and handles that aspect of the DBE program.
And just keep in mind that there really are no other agencies that have these DBE programs. In other words, the DBE program is a program run through the Department of Transportation that then flows down to the agencies at the state levels that receive these funds. So the states have their programs, but there's no other element of the DBE program that applies in other agencies.
So the DOT is responsible for developing the overall rules and regulations for the national DBE program that the recipients are required to follow and carrying it out in their state and in the locality. They provide guidance and oversight to make sure that those rules and regulations are being followed, and then they consider appeals from state and local certification or decertification decisions, and we'll talk about that a little later as well. So then moving on to the role of the recipients, state and local agencies, they actually perform the certification, certifying the eligibility of the firms to participate. The recipients must, they establish narrowly tailored goals for participation. They have to set overall goals for DBE participation in DOT-assisted contracts using specific methods that are provided in DOT's regulations. And again, the recipients may not use quotas or set-aside contracts. They just create aspirational goals that they try to reach. And they evaluate their contracts throughout the year and establish these goals as necessary to achieve the overall goal. And let's see, so while DOT is responsible for the DBE program rules on a national level, recipients may ask for and receive exemptions and waivers from specific DBE program rules, so it's important to check out the rules and regulations that apply to each state because there is a possibility that those can be different.
So for example, whenever we are approached by a company that wants to receive their DBE certification, we're very familiar with the DOT's rules as they should apply across all 50 states, but we also then go look at specifically what New York or Pennsylvania may require because they may have tweaked some of the rules.
Okay, moving on to the prime contractors rules. Contracts with DBE goals for subcontracting may only be awarded to offerors who make good faith efforts to meet the goal that's set out. And so prime contractors can meet the requirement of showing good faith efforts by either documenting commitments by DBEs, meaning that they've met the actual goal, or documenting their adequate good faith efforts to meet the goal. So they have to show that they took reasonable steps to achieve a DBE goal. And that this can be shown by performing market research and documenting the performance of the market research to find out what DBEs are out there in the market, attending matchmaking events to find a DBE partner and issuing RFPs to DBEs. Good faith efforts can also include efforts to assist interested DBEs in obtaining financial help, bonding, lines of credit, or insurance that may be required by the recipient or by the prime contractor. It can also include efforts to help DBEs in obtaining any necessary equipment or supplies or materials that might be required on the contract. And simply making a promise to use DBEs after the contract award is not going to be enough to show that you've made a good faith effort. You have to do more than that. In addition, the prime contractor has to identify the DBE firm to be awarded the subcontract. There has to be proof of commitment to use the DBE from the prime contractor and proof from the DBE firm itself that it will be used on that contract. The failure to meet the good faith effort requirements is considered a material breach of the contract. And then DBE subcontractors have the requirement of ensuring that all lower tier subcontracts include the good faith effort requirement. So they can't simply serve as a pass-through, and they have to make sure that there's a good faith effort all the way down the line to comply with the goals that are set out.
in a nutshell, the regulations sort of lay out some very specific things that need to be done by prime contractors in order to search out DBEs. And obviously DBEs who are familiar with this can do the same thing in terms of trying to look for firms that are going to be bidding on these kinds of contracts. And this is where oftentimes, attendance at matchmaking events around the country where there are conferences held, it's important to use those, both for prime contractors to attend to see what companies are out there that qualify for DBEs, and also for DBEs to meet and get introduced to the decision makers for some of these prime contractors. Because the goals, although aspirational, the result in the customer, state agencies, holding these prime contractors often accountable for whether they meet these goals. There is an investment that needs to be made by the parties in the relationship. So it really does take, working to build a relationship with their prime contractor who will put you on their team and make a commitment early on to use you, which is oftentimes not the way it works in the federal marketplace, where a large business may team up with a number of small businesses to meet subcontracting goals, but then may not ultimately award them subcontracts for a variety of reasons. Although there are regulations to stop that from happening, under the DBE program, there's more teeth into it because of the way the bids are supposed to be submitted and the representations made as to who's going to be used. And then once a company is used, as Jackie will say, we'll get into next, they just cannot be terminated.
Yep, following up on that, there's specific language in the requirements about how a prime contractor can terminate or substitute a DBE firm. That goes with showing the commitment or requiring the specific commitment by primes to use and stick with the DBEs. They can only reduce the amount of work committed to the DBE only for good cause and with the approval of the recipient. So they can't just make that decision on their own. They have to get approval to do so. DOT views reducing the amount of work committed to a DBE at the time of the contract award as a partial termination of the DBE's contract. And then again, going back to the good faith efforts, prime contractors must make a good faith effort to replace a DBE firm that can't complete its contract with another DBE firm to help ensure that the goals are met.
And the DBE firm that is then a replacement has to be a DBE firm that's doing the work under the same NAICS code, because to the extent that that's where the goals are supposed to be met, they just can't pick another DBE that perhaps is just not going to be doing the kind of work for which the goals were established under that NAICS code. Obviously, there may be significant other requirements under the contract that could perhaps be performed by a different DBE under different code. But if all the work is being done by other subcontractors, the prime contractor has to then look for a DBE that meets the same essential qualifications. With regard to the terminating and substituting DBEs, since you're dealing with a program that is run across all 50 states, it's really hard to say how this is being enforced on a regular basis. Some states may have enforcement officials that are much more strict, and others may just want the work done and not be as preoccupied if the prime contractor can give them a good reason why they perhaps terminated a subcontractor. If the subcontractor hasn't been performing the work correctly, or there are issues with performance, presumably most procuring agencies are not going to have any problem with the company being substituted so the work gets done, since that's normally their biggest priority. Now, with regard to the DBE certification standards, to make sure that those of you who are attending who are looking to participate in the program are questioning, who really is it that can participate. It's a program that is designed for for-profit small business concerns in which social and economically disadvantaged individuals own at least 51% of the company and also control the management and daily business operations. We've highlighted their for-profits to make clear that it cannot be a nonprofit entity that seeks to receive DBE certification. It's important for you to note that anyone who's applying for the program, it's their burden to prove their eligibility. And once once a company has provided the information that the states need in order to determine whether a company is eligible. So the balance shifts to the state to make a determination as to whether they're not eligible. Not that they're looking to deny folks, but there is significant scrutiny with regard to whether the burden has been met in establishing disadvantage. With regard to, go to the next page, the groups that are, certain groups are presumed to be socially and economically disadvantaged. And for those of you who are familiar with the 8A program, this is very similar to the 8A program, except, for example, under the DBE program, women are presumed to be socially and economically disadvantaged, which is not the case in the 8A program. However, Black Americans, Hispanic Americans, Native Americans, Asian Pacific Americans, subcontinent Asian Americans, and other minorities are presumed to be socially and economically disadvantaged. You should keep in mind that, again, this is very similar to the 8A program. With regard to the issue concerning other minorities, you still need to fall within certain groups. For example, if you look at the regulations, it says, Black Americans, and that has been interpreted as being individuals who come from Africa, not the northern parts, but the sub-Saharan parts of Africa. So, for example, someone that is from Libya or Morocco, etc., may not receive the same presumption. Those individuals who do not qualify as socially and economically disadvantaged because of the presumption is not there, they can still try to establish this. And this is where, for example, someone who is perhaps a service-disabled veteran may be able to try to establish the kind of social experiences they've had that have precluded them from advancing in the world, and why they're, and also if they can establish their economic disadvantage. With regard to Native Americans, just so you'll know that federal or state recognized tribes, as well as Alaska Native corporations and Native Hawaiian organizations, may also participate in the program. There are different rules for tribes and ANCs, and even different rules between tribes and ANCs. So the whole analysis that is conducted is different, but this is generally who this program is open to. The SBA essentially makes the designations of these groups, and the Department of Transportation completely accepts them. Interestingly, unlike the SBA's program and most of these other programs, people, lawfully admitted permanent residents are presumed to be disadvantaged, so you do not need to be a U.S. citizen to participate in the program. Also, being born in a particular country does not really matter. You have to still fall within one of these groups. And if the SB, if this is one of these areas that most often is the one that results in appeals of decisions when someone does not get in the program, if they're trying to meet these criteria but they don't fall within the presumed groups. Now, with regard to the presumption of social disadvantage, the SBA is supposed to go, the recipients or the states that are to be admitting firms are supposed to be looking to see whether the individuals that are applying to the program have really held themselves out to be within these different groups. It's not just a matter of checking the box that the department or the states look more carefully to see whether the individuals actually do qualify. And the agencies do require the applicants to produce appropriate documentation of their group membership. So this is, I believe, the genesis of this kind of scrutiny is because this is a program that has in the past had its constitutionality questioned, going all the way to the Supreme Court. So there is a real effort to check whether the individuals who claim to be members of different groups really belong to that group. Just because, for example, you have an individual who may have a Spanish surname, that does not mean that they will not check more carefully to make sure that person with that Spanish surname really has viewed themselves, and the world has viewed them as Hispanic, for example. Now, with regard to the criteria for regarding the presumption of economic disadvantage, in order to qualify for the program, you have to have a personal net worth that does not exceed $1.32 million. which for those of you who are in the 8A program would probably see it's a lot higher than to get in the 8A program, which has 250,000 net worth threshold upon program entry and 150,000 for continued participation. For this program, it's 1.32 million, and the reason for that is likely that many of these companies are performing construction contracts, and in construction contracts you need to have bonding capacity. So most of the individuals who participate in this program, if they're in the construction world, need to have more substantial assets than others in other programs. In order to establish that you are economically disadvantaged, you have to submit, signed statements, signed under penalty of perjury, indicating the individual's personal net worth and supporting documentation. And the agency may require, additional information. Just so just because an individual happens to be below this $1.32 million number does not necessarily mean that they're going to get in, because the agencies are allowed to look at a lot of other factors, such as if the individual in question has received gross income of more than $350,000 on average over the prior 3 years. Also, if it looks like their company has a fair market value of approximately $6 million, not taking into account any liabilities. If the number is above 6 million, a decision can be made by one of these certifying agencies to not admit someone into the program. Like the 8A program, there is a 2-year look back for any asset transfers, so they want to make sure that the individuals who are applying for the program have not transferred assets to immediate family members in a way that looks like they're trying to lower their net worth threshold. And for those of you familiar with the 8A program, if you were to look at one of these applications, you'd see that there is a significant overlap in terms of what the state is looking at. Next slide, please. Now, in calculating a person's personal net worth, there are certain exclusions, like in the 8A program, and if you're an SDB, an individual's ownership interest in the applicant firm is not considered, and the individual's equity in his or her primary residence is not considered. If there are any contingent liabilities, that is not going to be considered. The fact that you may owe money to someone. Also, interestingly, unlike the 8A program where whatever you have in your retirement account is also excludable, that if it's a legitimate retirement account, with regard to this program, there are specific rules that indicate that you exclude taxes and interest penalties that would accrue if you tapped into the retirement savings or investments, but otherwise those funds do count against an individual. It was a $1.32 million calculation. Now, with regard to demonstrating ownership, in order to participate in the program, you have to demonstrate that you own 51% of the company. And if it's a corporation, it has to be 51% of the stock. If it's an LLC, it has to be 51% of the membership units. And if it's a partnership, they look at whether you have 51% of the membership interest. And similarly with any ownership interest that may be in some kind of a different structure, it has to be evidenced that the individual upon whom eligibility is based owns 51%. In looking at the companies to determine whether they're actually owned by an individual that claims to be the 51% owner, the Department of Transportation mandates that these certifying agencies look to see exactly where the assets came to acquire one of these companies. Because they police this program so carefully, they want to make sure if an individual who's a DBE, if they've acquired the company from someone else, they want to make sure that they actually paid a fair market value for it. If an individual has created a DBE company from scratch, they want to see what kind of capital contributions have been made in order to qualify the firm, to start the firm and have a real vested interest in it. To the extent that an individual borrows money to start their company, If those loans are not secured, that may not be viewed as a legitimate kind of transaction because they question who would be lending money to an individual to start a company that hasn't provided some security. In a nutshell, they want to make sure that the individual is a real and substantial contractor formed by an individual that has skin in the company. There are also special rules that apply. For example, when there are marital assets, like the 8A program, if you live in a community property state, they view whatever assets you have that are yours and your spouse's are split in half. But to the extent there is a company that operates out of a community property state, they will treat that company as owned, half and half by the spouse, unless the spouse demonstrates through documentation that they're giving up their interest. If there is a divorce, the certifying agencies need to view those divorce papers as final. They cannot be questioned how it is that the property is being split. Or if an individual happens to have acquired a company through an inheritance, it's understood that there are certain ways that individuals become owners of companies that are eligible for the DBE program, even though they may have not made the kind of investments that the Department of Transportation expects individuals to make. The regulations also recognize that there may be individuals that don't have really too much money to start a company, but they may own a 51% interest in a company because of special expertise they bring, such as in that expertise or the services they're providing are in themselves the capital contributions. In order to be able to establish that your expertise is your basis for your capital contribution, you need to show that you really have you're in a specialized field, that the qualifications you have are outstanding, that they're absolutely critical to the operations of the company and indispensable. That has to be properly documented. And a little problem that I see in the regulations is that it does require that you still show some kind of a significant financial investment in the company, which normally when individuals sometimes capitalize these firms, they don't have too much money to put in them. And they may bring in minority owners that invest in the company, and they're providing their expertise. So any individual who is looking to start a DBE needs to be thinking very carefully how they're going to establish that they were really behind the startup of the company and or made the investments to get their company to the next level, such as if you buy it from an individual whom you don't pay that much, but it's because of what you bring to the table with your expertise. How has all this been properly documented so it doesn't look like the individual who owned the company is now just bringing you in as a front for them? Jackie, is there any other issues here you see with regard to ownership?
Yeah, I would also just point out the regulations require that the owner must be entitled to profits and loss commensurate with their ownership interest. So that's something that they're going to be looking for when they're looking for whether there's appropriate ownership, whether you're also getting the profits in the same amount as your ownership interest.
Okay. Let's turn it to the next slide.
Mm-hmm.
Now, one of the most important elements of participating in the program is that you have to demonstrate that it's an independent business. And in looking at whether a company is independent business, they want to make sure the company is viable without having to depend on another firm. And so what the agencies will look at is what kind of relationships exist between the applicant and other non-DBE firms, prime contractors, also companies that perhaps are owned by former employers, similar to the kind of analysis the SBA would do if it's looking to see whether two firms are affiliated. But this is more focused on whether there's potential for control. And in looking at the kind of relationships that they question between a applicant and non-DBEs is whether there seems to be sharing of personnel, facilities, equipment, bonding support, or if it looks like there's a consistent relationship of the two companies working together. With regard to the corporate documents, you cannot have bylaws, shareholders agreements, or operating agreements that basically give the non-disadvantaged owners veto power over control over these companies. And usually you're talking about significant decision making. But no, you're normally talking about day-to-day operations of the company. Remember, each state does apply these rules somewhat differently, in terms of what's control. And in some states, you may find that giving veto power to the minority owner over some major decisions is going to be fine, particularly if state law mandates that all the owners have some say in some major decisions. But in some states, there's nothing to that effect, and the parties may, by agreement, decide that some major actions are okay. But those could be a problem in certain circumstances, because most people don't just give unfettered control to another individual. But those individuals that are investing in DBEs, and they're not the eligible individual, should note that they should not have any control over the company in a way that could anyway lead to there being a question as to whether the individual upon whom eligibility is based actually controls it. The individual upon whom eligibility is based has to have the highest officer position, but interestingly, it does not have to be the highest paid. However, if that individual is not the highest paid person, they need to show why. Somebody else within the company is receiving more than they are. And to the extent that there are non-disadvantaged individuals involved in the management, et cetera, of the company, they cannot have disproportionate responsibilities over the operations of the firm. The majority of the responsibilities have to rest in the individual upon whom eligibility is based. And if you have a partnership, for example, there can be no documentation that would suggest that any one of the partners can bind the partnership. It has to be very clear that in order to bind the partnership, only the individual upon whom eligibility is based, always that individual has to be signing any kind of contracts and binding commitments. You should also that outside employment that an individual may have, it should not, cannot conflict with the management and control of the firm, but it's not precluded that an individual have some kind of other employment, so long as it doesn't interfere with their ability to run the company. And an individual may delegate, different kinds of responsibilities, so long as the big ones that involve critical decision making and their expertise, etc., are the ones that they're making. And you cannot be viewing an individual as eligible if what they really do is manage the company by taking care of administrative tasks and office management and or bookkeeping while other people are actually doing the work that is technical. It's critical that the individual upon whom eligibility is based is also someone that knows the kind of work that's being done, because then it may look like they really can't operate the firm without the folks that provide the more technical, meet the more technical requirements of the opportunities the companies have. Jackie, is there anything else with regard to control that you recall we need to go over?
Yeah, running off of your last point, the firm will only be certified only for the NAICS codes in which the DBE owner has the ability to control the firm. So if the firm happens to do different types of work, but the DBE owner is specifically involved or has control only over some parts of the work, then the certification is only going to relate to those specific NAICS codes, not necessarily all of the work that the firm does. Also, if the DBE firm is transferred to the disadvantaged individual from a non-disadvantaged individual, but the non-disadvantaged individual remains involved, there's a rebuttable presumption of control by the non-disadvantaged owner individual unless the DBE owner shows that the transfer was made for reasons other than obtaining DBE certification and that the DBE owner actually does have control.
So these are issues just to keep in mind if an individual wants to acquire the interest from someone else, but that other person still is going to be involved in the company. Now, lastly, one of the more significant requirements is that in order to qualify for the program, you have to be a small business and meet the SBA size requirements. And this is critical not only for those of you who are applying for the program, but also for those of you who are looking to do work if you're a prime contractor with a DBE, that you need to be mindful that these companies need to meet these criteria. And there's an interesting one with regard to the DBE program, in that under the DBE program, any company that exceeds on average $23.98 million in receipts is considered to be large and not eligible to compete for these contracts, which, as many of you may know, under the SBA's program, there's a much higher size standard for construction. It's, I think, $36 million. But that, if you're in construction and you're an 8A firm that has $32 million in average revenues, you would not qualify for this program because you have to be below the 23.98, and you also have to be small under the size standards applicable to the NAICS codes under which you're applying for the program. Under this program, when you apply, you indicate to the certifying agency the NAICS codes under which you're going to be doing work, and you have to be small under those NAICS codes. Clearly, all these are NAICS codes that would be below the 23.98 million. And you need to be mindful of the fact that when you're in the program, if you exceed the size standards under those NAICS codes, you need to notify the certifying agency so they no longer view you as a small business under that specific NAICS code under which you entered the program. There's essentially two elements to this. You have to be less than 23.98, and you have to be small under the NAICS codes under which you are trying to get into the program.
And then those NAICS codes that you're certified for have to be the NAICS codes that are on the contractor, so the subcontract that you're going to be performing.
Right. A contractor cannot claim DBE credit if they give you a subcontract, but for work that is not one of the under one of the codes which you entered the program.
Okay, we're going to move on to the actual process for certification now. The DBE federal regulations require that the recipients agree to certify DBEs using a unified certification program. So under the unified certification program, applicants in every state fill out the same unified certification application. So each state will have its own UCP, but they all use this unified certification application. And then the state and local transportation agencies certify the eligibility of the DBE firms based on the regulations and guidance from DOT. So the recipients must participate in the UCP program established in each state, and the UCP provides one-stop shopping so that an applicant only has to apply one time for DBE certification that will be honored by all of the recipients that are using the federal funding for the different highway or transit or aviation projects in that state. The UCP is not required to process an application from a firm with a principal place of business outside the state if the firm is not certified in its home state, which is where it maintains its principal place of business. So basically, you should get certified where you have your principal place of business first and then reach out to other states to try to get certified in those other states. And a second or third or fourth state, they can choose to simply accept the certification from your home, from the DBE's home state. And you know, if you're certified in that one state, then they say, okay, we accept that certification and that's good enough. But the follow-on states don't have to simply accept that certification. And if they choose not to do so, then they have to follow specific procedures. In that case, the DBE applicant would have to provide all the materials that they provided to the home state, correspondence with the home state, their first application, and those supporting materials, correspondence with any other state UCPs if they've been certified by other states or not been certified. If their certification has been denied, they have to provide that information as well, and any certification appeal information, as well as an affidavit that the information they're submitting is correct. And the second state would request materials, including a site visit report and evaluation of the DBE firm from the home state within 7 days of the application and make its decision within 60 days of the application. So this is for the for follow-on states. And then the second or third, whatever state, must certify the firm unless it has good cause to believe that the first certification by the home state was erroneous or should not apply for some reason. In order to qualify, the UPC will consider the application and any supplemental documents. These include documents related to the legal structure, ownership, and control of the firm, the bonding and financial capacity of the firm, lease and loan agreements, bank account signature cards, the work history of the firm, such as contracts it has received and work it's completed, as well as payroll records, a list of the equipment owned by or available to the firm and the licenses the firm and its key personnel possess in order to perform the work that it seeks to do as a DBE, and then complete federal income tax returns filed by the firm, its affiliates, and the disadvantaged owners for the last 3 years. The UPC is required to conduct on-site interviews of the officers, which will also include a review of resumes and work histories of those individuals. And it can also interview key personnel if it feels that's necessary. It will also perform, it's required to perform an on-site visit to the firm's principal place of business and any job sites in the local area. And then the requirement for the certification in the home state is to be made within 90 days of receiving the application, but there are some exceptions to this. The 90 days only runs once the UCP has all of the necessary supporting information. So if in the initial application the UCP feels that it needs some more supplemental information, and there's a lot of back and forth between the applicant and the UPC, then that 90-day deadline won't start until it feels that it's received everything that it needs. And then there's a potential 60-day extension under certain circumstances. In terms of the requirements for remaining in the DBE program, once certified, the DBE firm remains certified unless the UCP removes the certification for certain reasons. So you don't have to go through, unlike other small business programs, you don't have to go through a recertification every year or a few years, but you do have to submit an affidavit annually, which says that there have been no changes in eligibility or other material information in the application, and that the DBE meets the size standards and the overall gross receipts cap. And the DBE has to provide tax returns that will support the affidavit. Additionally, if there are changes in circumstance relating to the eligibility standards or any information, material information in the application, then the DBE is required to notify the recipient of that in the form of a notarized affidavit or an unsworn declaration within 30 days of the occurrence taking place. And it needs to document what those changes are. A certification review by the UCP, such as an unannounced on-site review, may take place in light of changed circumstances. And if the DBE firm fails to make the notification in the 30 days as required, it'll be deemed to have failed to cooperate, and that could result in its removal of eligibility. The recipient, the UCP, could also temporarily suspend the DBE if it fails to notify the recipient of material changes, fails to timely file its annual affidavit of no change, or if there's evidence of a change in circumstances affecting its eligibility. A firm that's denied certification can appeal to DOT.
That would be DOT here in Washington, D.C.
The appeal is due no later than 90 days after the date of denial or removal of certification. So you can also appeal if the certification is removed, as well as if the application is initially denied. The state, following a denial of certification, the state may impose a waiting period before reapplying of no more than 12 months. So that's a potential impact from the denial. There is an inability to appeal the temporary suspension if the UCP decides to suspend the firm. An appeal decision is not binding on other recipients, so even if there's an appeal with respect to the application or the certification in one state, that doesn't necessarily apply or have to be followed by other states. If a firm's decertified, then there are specific circumstances about whether the participation can count towards the DBE goals, depending on the reason for certification. But one thing I want to mention there is that if the ineligibility is caused by exceeding the side standard during contract performance, then the DBE's work will still count. So while if there's ineligibility for certain other reasons, then the DBEs work may not count towards overall goals. If it's just because the DBE exceeds its size standard during the contract performance, then it will still count towards the overall goals. I just want to touch real quick on some similar programs. Tony mentioned before that individual states and localities, most of them do have minority-owned business programs referred to as MBE programs. Some of these allow you to use the joint MBE-DBE application where the UCP will serve as the application for the MBE program as well. Not all of them allow this, but some do. For example, Maryland does use a joint application, but Virginia does not. There's an estimated 15 states that have formal targets for awarding contracts to MBE. For example, Maryland aims for 29% MBE participation, at least in 2014 and 2015. But you need to be aware that these programs don't necessarily follow the same regulations as the DBE program. States can set whatever regulations they want, and they can be, we've seen them be more lenient and also more stringent than DBE program requirements. So you really have to dig into those regulations as well to figure out what those requirements are. And for instance, Maryland's MBE program has a higher personal net worth cap. Theirs is $1,692,682,000, whereas, as we've mentioned, for the DBE program, it's $1.32 million.
Lastly, one of the things we wanted to make sure we brought to our audience's attention is that there has been an effort to open the program up to veteran-owned small businesses. That has not passed through Congress, but there is an effort to expand it to veteran-owned small businesses. So it may be that in the next year or two, we're not sure when, it could be sooner, that veteran-owned small businesses are also eligible to qualify for the DBE program. Now, we're basically at the end of our presentation, and we were supposed to end at 3 o'clock. I know that we wanted to take some questions from the audience, and we did unfortunately run a little bit late because of a little glitch getting our webinar going. So I do want to go ahead and answer a few questions that we've received from the audience. One of the questions we were asked is, what is a typical processing time for DBE applications? And each state is different. As Jackie said, agencies are supposed to let you know within 90 days, but they can also actually extend that by 60 days. If they can't do it within 90 days, it all depends on how quickly you're able to get all the material in to the agency. One of the other questions we had here is with regard to what happens if you if you made a misrepresentation, or the way it was actually put in this question is what happens if you've lied on your application. And the regulations are clear that a company that is viewed to have engaged in misrepresentations is subject to a suspension or debarment, and also they may be subject to civil and criminal penalties under different statutes that are specifically laid out in the regulations. That depends on whether the state authorities refer that to the Department of Justice for prosecution, but clearly anyone who's caught is found to have made some kind of misrepresentation in either reporting their goals or in their applications can find themselves with significant penalties. Another question we received is, do you ever graduate from the DBE program? And as Jackie said, no, you don't graduate. You every year have to provide information indicating that you're eligible, and you can be terminated from the program if you're no longer eligible, but you're otherwise in the program as long as you meet the eligibility criteria. One of the other questions we have here is, we have many of them, in what way does the DOT Mentor Protege program come into play, given the fact that the SBA has this new Small Business Mentor Protege program and its 8A Mentor Protege program? And the DOT has their Mentor Protege program, which they view as providing the kinds of benefits that the SBA's does. But the only program, that Mentor Protege program, that really allows firms to not be affiliated is the SBA's program. So to the extent that there is this 1 year since the SBA issued their Small Business Mentor Protege program for different agencies to work with the SBA to either renew their own programs and make them conform to the SBA's program, or basically get rid of them. We're probably still in that, we're in that middle of that year, because that SBA Mentor Protege program was only implemented like 6-7 months ago. And so the year will be up this coming, I think, August 24th. One of the other questions we received was, how do, tribes, can tribes apply for the program? And tribes can apply for the program, but interestingly, if you look at the DBE regulations, if a tribe has one of their entities apply for the program, the tribal entity must be run by an individual who's deemed to be socially and economically disadvantaged. So the tribe has to have an individual who they've identified who is socially and economically disadvantaged and meets the criteria that would normally apply to an individual. That person does not have to be a tribal member. That person can actually be someone who's African American, Hispanic, that meets the other presumptions. That is not the case for Alaska Native corporations. Alaska Native corporations have a different set of rules that apply for their participation in the program. Interestingly, too, for tribes, that the rules indicate that the companies have to be small, and although they will not view these entities as affiliated with other tribal entities, so they could still, there's no risk that one of these DBE applicants for a tribe is going to be affiliated with one of their larger entities. It still has to be demonstrated that these entities are operating fairly independently of each other without the resources of one helping the other. And when you look at those regulations that the Department of Transportation has for DBEs owned by tribes, it does in many ways conflict with the SBA's rules. And that has posed challenges to many companies that we have worked with that are applying for the program. And we can, of course, help any of our attendees here if they have issues regarding trying to participate in the program and learning about them, since we've been dealing with this for so many years.
I see somebody's asked about whether states or localities maintain databases of certified DBEs. The DOT's regulations do require recipients, which would be the state and local agencies, to maintain records of the certified DBEs. And I think that most states do provide that database online, but they do have records of the certified DBEs. That's a requirement of the program. And I think that I didn't mention when talking about the difference between the DBEs and the MBEs, the main difference there is that for the MBEs, which are the state-run programs, those just deal with the state funding, whereas DBE is the federal funding that goes through the states and is eventually for contracts that are through the states but using, they're assisted with federal funds, whereas the MBE program just uses state funding. So that's another marketplace to expand to.
Real quickly, a question we've received from several folks is whether the DBE program is in any way a self-certifying program. And just to make clear, it is not a self-certifying program. You do need to go through a process to be certified. But if you recall from the discussion a few minutes ago, if you've been certified in your home state where it's a principal place of business, and you go to another state to become certified, the other state can take your certification in state number 1 for purposes of being certified in state number 2. And in many ways that is sort of like a self-certification, in that you're going to state number 2 and telling them, yes, look, I'm eligible because I'm already a DBE in this other state. Another question we've received is regarding a company that received their DBE certification from the Commonwealth of Virginia, and they're anxious to learn about how to optimize the growth via that program. And that now becomes sort of a marketing issue. It's a matter of how you introduce yourself to other companies that in the construction field that are doing work with the Department of Transportation or that have or through DBE funded projects, so that they realize that you are out there and you should be put on a database of firms that's DBE certified by the state, so that larger businesses can locate you. Although I'm not too sure if large businesses just go through that list to pick firms willy-nilly, although they may use that list to provide bid and proposals, because they do need to demonstrate that they're reaching out to companies by sending them solicitations to submit bid and proposals as subcontractors. we have many, many more questions, and what I think we'd like to do, since we don't want to keep you all on very, very busy, and this has gone beyond the time we'd allotted, we will look at all the other questions that we've received, and we will try to answer them individually. It's normally what we do when we give a webinar. We may not be able to answer them in the next 24, 48 hours, but we will try to do them in the next week or two. We do appreciate that you've all tuned in to us, and I look forward to hearing from you in the future if you need any of our services here at Polero Mazza. Thank you very much. Have a good day.